Hi, everyone. Thank you for joining. We are going to start in just a moment. Thank you all for joining.
Alrighty. Well, hello everyone. Welcome to A Better Balance's Know Your Rights webinar on pregnancy and COVID-19. My name is Dina Bax, and I am the co-founder and co-president of A Better Balance. And I'll be joined by my colleagues, Elizabeth Goodmark, ABB Vice President, and Sarah Brofman, ABB Senior Policy Counsel and Director of our DC office. Today's webinar will be recorded and the slides will be shared with participants. Also, there is a question box at the top of your screen, and we'll do our best to address as many questions as we can with the time we have. So, A Better Balance, if you're not all familiar, is a national legal advocacy organization with offices in New York, Nashville, DC, and Denver. And our mission is to leverage the power of the law to ensure workers can care for themselves and their loved ones without risking their economic security. Along with paid leave and paid sick time, one of our core priorities is ensuring that pregnant workers are treated fairly so they can remain healthy and on the job. And since our founding, ABB has been on the front lines fighting to ensure that pregnant workers know their rights and have the strongest legal protections possible. As we see up close on our free helpline, when pregnant workers are forced off the job, it too often snowballs into lasting economic disadvantage for pregnant workers and their families, especially women of color. There's no doubt this pandemic has been frightening for us all. There is much that healthcare providers and researchers are still trying to learn about the virus, including its effects on pregnant women. According to the latest guidance from the CDC, the agency does not, quote, currently know if pregnant people have a greater chance of getting sick from COVID 19 than the general public, nor whether they are more likely to have serious illness as a result. Based on available information, pregnant people seem to have the same risks as adults who are not pregnant. That being said, the CDC does mention that pregnancy does lead to bodily changes, and pregnant people have developed severe illness with other viruses similar to COVID 19, and those with certain underlying health conditions, such as heart disease and diabetes, may be at greater risk of contracting severe illness should they get COVID 19. We all, and based on the fact that pregnant people have developed serious illness from other similar viruses like SARS, the American College of Obstetricians and Gynecologists on its website currently has advised that, quote, pregnant people should be considered an at risk population for COVID 19. I think we all acknowledge that more research is needed here. What remains constant, however, is that pregnant people will need and should seek specific recommendations from their healthcare providers about their health risks, which will depend not only on guidance, but their own specific needs and personal medical history. Every pregnant worker's health needs are different and may vary from month to month. So, with that being said, like the rest of the population, ACOG advises pregnant women to take proper precautions, including staying at least 6 feet away from other people and staying home as, quote, much as possible. Yet, that's not possible for the women, especially women of color, who are bearing a huge brunt of the essential work during this crisis. According to the Center for Economic and Policy Research, nearly two-thirds of frontline workers are women, and people of color are overrepresented in these industries. For instance, women make up over 90% of housekeepers and maids. Nearly 70% of workers in that industry are people of color. Close to 90% of home health care aides are women, and over half of those workers are people of color. Women make up over 70% of the cashiers in this country, and again, nearly half of all cashiers are people of color. And at any given time, and an unknown number of them are pregnant, but it's likely in the thousands. We know there is a huge maternal health crisis in this country, disproportionately impacting Black women and women of color because of structural racism. We know there are many factors contributing to this crisis. Today's webinar is going to focus on one important piece. That is ensuring that pregnant workers, especially those on the front lines, can stay safe and healthy as possible during their pregnancies while continuing to earn a paycheck. With this backdrop in mind, the purpose of today's webinar is to highlight the workplace laws that do exist that can help pregnant workers assert their rights amidst this crisis and beyond. Knowledge is power, yet there are important limitations which you'll hear about throughout the webinar. We certainly have a lot we want to cover today. We'll be discussing federal or nationwide laws and state laws that may offer protections to you as a pregnant worker in a variety of scenarios. In some cases, even if one law doesn't apply, another one may. What we'll cover today are your potential rights if you need workplace accommodations related to your pregnancy and COVID 19, you're experiencing pregnancy discrimination, you need paid or unpaid time off if you're unable to work due to your pregnancy and COVID 19 related issues but want to return to your position, you need lactation accommodations if you're working and breastfeeding, and we'll touch on your rights to unemployment assistance during COVID 19. We also want to provide you with a bit of a cheat sheet about the key laws we'll be discussing today. You'll see they are broken down into two buckets: laws that are permanent and laws that are specific to COVID 19 and may expire this year or only relate to COVID 19. You notice that a lot of these laws are indeed permanent, and so although we'll mostly be discussing a lot of these in the context of COVID 19, many of these apply to other circumstances during your pregnancy. So I'm just going to kick it off in a conversation around workplace accommodation, then I'll turn it over to my colleagues. The first type of scenario we're hearing from pregnant workers, especially those working in healthcare and essential services, are scenarios where workers are still going into work but may have an underlying disability or a medical need related to their pregnancy and require modifications to stay healthy and working during their pregnancy. So, one common scenario that's arising is as follows: I'm pregnant and work at a grocery store. I have gestational diabetes, and I'm nervous in my health during this crisis and staying safe at work. I also have a friend working at another store who is pregnant and has respiratory issues and shares similar concerns. Are there any changes she and I can ask for in the workplace to ensure we can stay safe and healthy while working? So, because both of these workers have underlying conditions, the first key law that should apply here is the Americans with Disabilities Act. Under that law and the Americans with Disabilities Act, Amendments Act, if you work for an employer with 15 or more employees and have a pregnancy related impairment that substantially limits a quote major life activity, including majorly bodily functions, you may have the right to receive reasonable accommodations so long as the accommodation does not impose an undue hardship on the employer. So, what are pregnancy related impairments or disabilities? There are hundreds of cases in EEOC guidance fleshing out this very question, and happy to discuss them further with any of you. But based on both guidance and case law, both gestational diabetes and severe respiratory illnesses issues likely qualify as a pregnancy-related disability because both medical conditions are sufficiently severe and substantially limit a major life activity, and because those two issues may also put someone at greater risk of severe illness if they contract COVID 19. Other types of pregnancy related disabilities include preeclampsia and pregnancy related anemia. Unfortunately, not all pregnancy related conditions trigger the ADA. The standard is quite high, and we've seen too many cases that deny coverage to pregnant workers accommodations they need because their conditions fail to constitute a disability. And that's why we need a pregnant worker fairness law and the Federal Pregnant Worker Fairness Act, which we'll hear more about a bit later. But so moving on to the next slide, in addition to typical accommodation requests in this public health crisis, we're seeing workers with disabilities, including pregnancy related disabilities, asking to reduce the risk of exposure to COVID 19. So, what are common requests? Well, making changes to your workplace to reduce contact with others, temporarily changing some of your duties, modifying your work schedule, temporarily transferring positions, requesting to telecommute. It's important to note these are all examples of accommodations cited in the EEOC's pandemic specific guidance and FAQ for workers with disabilities. Um, the EEOC, this is the agency that enforces the ADA, recently said so long as it does not impose an undue hardship on an employer, if an employee has an underlying disability that puts them at risk of severe illness if they contract COVID 19, there are reasonable workplace accommodations that can be provided to prevent exposure. So, just a little bit, how do you go about requesting an accommodation? The first step is what's called the interactive process of the ADA is to let your employer know that you have a need for an accommodation. You must inform your employer that you're requesting an adjustment or change at work for a reason related to a medical condition. You do not need to use the exact phrase reasonable accommodation or even ADA. You can use plain English. After you've made the request, your employer can ask you to provide a note from a healthcare provider to confirm you have a disability. If your boss does not request a note, make sure it is as specific as possible and outlines exactly what you can and cannot do at work. Make sure your healthcare provider avoids using vague terms like heavy lifting or light duty, which as always may be interpreted by your boss to mean you can't no longer do your job. You want these notes to be very narrowly tailored. For guidance for how to ensure you submit a clear note from your healthcare provider, visit babygate.abetterbalance.org or the Center for Work-Life Law for template doctor notes for each state. Now I'll turn it over to my colleague Elizabeth Genmark to discuss laws that may help you if you don't have a pregnancy-related disability. Elizabeth?
Thanks so much, Dina. And just as a reminder for those of you who may have joined late, we will be providing a copy of these slides to participants. So now let's turn to a different scenario. So, what happens if it's not clear if you have a pregnancy related disability? What rights do you have then to accommodation? So, for example, what if I'm a food service worker, I'm pregnant, and I'm worried about my health and safety at work, but it's not clear that I have an underlying disability? What rights might someone have to accommodation? So, if you work for an employer with 15 or more employees, then you may have the right to an accommodation under the federal law called the Pregnancy Discrimination Act, even if you don't have a disability associated with your pregnancy. So, under this law, if your employer is providing accommodations to other employees similar to you, but refusing to provide you with an accommodation, then that could be a violation of the law, and they would need to provide you with the accommodation. So, to figure out if your employer is accommodating workers, you may need to ask around about how your employer treats other non pregnant employees who have needed an accommodation at work. So, for example, does your employer have a policy of only giving light duty to those with on the job injuries? Or do they have no problem helping out folks with non pregnancy related disabilities, but refuse to help out pregnant workers? If so, this could mean that they are required to provide you with accommodations. But you may not have time to figure out what accommodations your coworkers are getting. And in many instances, you might need immediate relief. And it might be challenging to find out how coworkers are being treated. So, as we've written in A Better Balances report, long overdue, this standard can be really, really challenging. That's why there are also very important state laws that may be able to help you in this situation. 29 states and 5 cities now have greater protections for workers who need an accommodation related to pregnancy. Most of these laws use a similar framework. An employer must provide reasonable accommodations if you have a limitation or medical need related to your pregnancy, and often related to childbirth or other pregnancy related conditions as well. And what's different and really important about these laws is that you do not need to show that you have an underlying disability, as is required under the ADA, like Dina talked about. Nor do you need to show that other workers are also being given accommodations as required under the PDA. So that's why these laws are so important and why we need a federal standard, which Dina will talk more about later. We've seen time and time again how beneficial these laws can be. What's so effective about pregnant workers' fairness laws is that What it entails is an employee going to her employer, asking for an accommodation, and trying to find an accommodation that works best for both employer and employee. No need to look around at what others are doing, and no need to prove you have an underlying disability. And this helps lead to quick and informal resolutions, which really is what pregnant workers need and want the most. So, the process for getting an accommodation under this type of law is fairly straightforward, and it consists of asking your employer for an accommodation based on a limitation, medical need, or condition you have related to your pregnancy. Again, doesn't need to be a disability. Now, the language may differ from state to state, so it is important to look at your specific law. And we have state by state resources that we'll talk about later. So, typical accommodations include light duty, bathroom breaks, temporary transfer, the ability to carry a water bottle on the job. And in the current crisis, accommodations may include some things that we've already discussed, like changing your work schedule or a transfer, or perhaps teleworking if no other accommodation is available. Generally, the same list of accommodations available to workers with disabilities per the ADA that Dean already discussed. Then your employer works with you on an individual basis to come up with an accommodation unless it would cause an undue hardship, meaning it's very difficult or expensive for them to provide. Lastly, in the workplace accommodations bucket we'll discuss today, there's also a federal law called the Occupational Safety and Health Act that says that your employer is required to provide employees with a workplace that is free from recognized hazards likely to cause death or serious physical harm. The Occupational Safety and Health Administration, OSHA, has released guidance that provides recommendations on how workplaces can best prepare and protect their workers from COVID-19, with recommendations tiered based on your workplace's risk of exposure. Unfortunately, this guidance is not law and does not create any new obligations or requirements for employers. However, if you think your employer is failing to put protections in place, you can file a complaint with OSHA, although note that current enforcement is limited. Now we want to move to another type of question we're getting, which is often as follows: I'm pregnant and my boss just terminated me, saying I won't work as hard as my colleagues because I'm pregnant and I should be at home resting anyway. Is this illegal? The answer is this is likely illegal pregnancy discrimination if you are covered by the Pregnancy Discrimination Act, the federal law we already discussed, or a state anti discrimination or civil rights law. So, under these laws, your employer cannot treat you differently from other employees based on your pregnancy. So, if they are taking action against you but not others because you're pregnant, like they're firing you, cutting your hours, or forcing you out, that could be pregnancy discrimination. If you work for an employer with 15 or more employees, you're covered by the federal law. And state laws may have even lower thresholds providing coverage if you work for a smaller employer. So, in this scenario, the employer is clearly targeting her because of her pregnancy and treating her worse. So, this would point to a violation of the law. It's also important to note that many pregnant people have intersectional identities and may face multiple forms of discrimination. If you are a woman of color and you think your boss is also treating you differently, not just because you are pregnant, but because you are a person of color, like he's providing accommodations to white employees who are pregnant, but not Black employees who are pregnant, then this could be race discrimination. The same federal law that protects you from pregnancy discrimination also protects you from discrimination based on race. Now I'll turn it over to my colleague, Sarah.
Thank you, Elizabeth. And just as a reminder, we will be sharing these slides at the end of the presentation. And I'll say we are now going to cover paid time off and unpaid time off. And following that, we'll be covering lactation accommodations and unemployment assistance. So the next big area of law that we wanted to touch on are your rights around leave. And there are several laws that we're going to cover today. Some are related only to COVID-19, and others are permanent leave laws. It's also important to remember that your right to leave also depends on whether you're covered by the law and the purpose for which you need leave. A common scenario that we're hearing is as follows: I'm pregnant and work for a small restaurant chain coordinating takeout, but my healthcare provider advised me to self quarantine because they fear I may have been exposed to someone with COVID-19 and I'm exhibiting symptoms. I now need to take leave, but I want to return to my job. What can I do to receive income while I'm not working? The first law we're going to touch on is the Families First Coronavirus Response Act. This is a federal law that passed just a few weeks ago specifically to provide paid leave for workers impacted due to the coronavirus. It should be noted this is the first time in US history that Congress has passed any sort of national paid sick leave or paid family leave law. But as we will note, it applies only to COVID related needs, which we'll discuss in more depth. And it's also not a permanent law, meaning that it'll sunset at the very end of this year. In our scenario, the worker works for a small restaurant chain with probably 60 or so employees, so she is likely covered by the law. To be eligible under this law, you must work as an employee in any public agency, regardless of the size, with some limits for federal employees, or work for a private entity with fewer than 500 employees total. Not only are those who work for employers with more than 500 employees exempt, but employers can also exclude healthcare providers and emergency responders, which unfortunately the Department of Labor has defined extremely broadly. And you also may be excluded if you work for a business with fewer than 50 employees, because employers can opt out fairly easily without filing any paperwork with the government. These exemptions, we want to point out, mean tens of millions of workers are not covered by this law. A recent study from the Center of American Progress found that 68 million are excluded from coverage because they work at large employers, and an estimated 38 million more could be exempted because they work for very small employers or work as healthcare providers or emergency responders. This means at best only 47% of workers, and at worst 17%, are eligible for paid leave under the Families First law. Returning to the worker in our scenario, since she works for an employer with 60 employees and isn't a healthcare provider, she should be entitled to take up to 80 hours of paid sick leave in her circumstance under this law. And we want to note all the purposes for which emergency sick leave can be taken. The first is if you've been advised by a healthcare provider to self-quarantine due to COVID-19 related concerns. If you have COVID-19 symptoms and are seeking a medical diagnosis, you're subject to a quarantine or isolation order. And it should be noted that this includes stay-at-home or shelter-in-place orders. You need to care for someone who is subject to a quarantine or isolation order, or who has been advised to self-quarantine, or your child's school or daycare is closed due to COVID-19. We also want to briefly mention that this is for emergency paid sick leave. The Families First law also requires that employers provide up to 12 weeks of paid family leave, which includes 2 weeks of emergency sick leave for school or daycare closure, an additional 10 weeks if the worker has to care for children due to school closures. But it is specific to school closures. The next question that often comes up is, well, how much will this worker get paid? If you are taking emergency sick leave for your own health needs, as is the case in our scenario, not to care for someone else, you must be paid 100% of either your regular rate of pay or the federal, state, or local minimum wage where you are an employee. And that's particularly important for tipped workers. However, your employer is not required to pay you more than $511 per day or more than $5,110 total. This type of leave is provided and paid for by your employer, so you do not need to apply to the government for it. You will need to notify your employer, and your employer may require certain documentation. It also is important to note that the pay is coming from your employer, but the employer can get fully refunded for the leave they provide you through tax credits from the government. If you qualify for paid leave under Families First, that leave is in addition to, not instead of, any other paid sick leave you may have accrued, including if you have a right to sick leave under a state or local paid sick leave law. 12 states, Washington, D.C., and dozens of localities guarantee workers a permanent right to paid sick time. Some of these permanent laws also have specific closure provisions that may allow you to stay home to protect your health during times of public health emergencies. These laws can also be used if you need to attend prenatal appointments or have other pregnancy-related medical needs. And there are also a number of states and localities, such as New York State and San Francisco, that have passed emergency paid sick leave laws to help fill in some of the gaps we described earlier in the federal Families First law. For more information on the Families First law, state paid sick time laws, and state or local emergency paid sick leave laws, please visit A Better Balances COVID-19 resource page, where we have detailed resources and FAQs to help you navigate these laws. Now, there's another bucket of laws that may be helpful to our worker in this situation, and those are temporary disability insurance or state paid medical leave laws. Under this type of law, which unfortunately only a handful of states have, you may be entitled to partial wage replacement if you are unable to work due to a serious health need, which could include COVID-19 or symptoms of COVID-19. And we also want to flag the Family and Medical Leave Act. And the reason for this is that if you need time to attend prenatal appointments or have an incapacity related to your pregnancy, then you may be entitled under this federal law to take up to 12 weeks of job protected, however, unpaid time off, either all at once or on an intermittent basis. We want to note, however, that if you're taking paid family leave under Families First for school closure reasons, meaning that 12-week chunk of time, that time will count against your 12 weeks. And that includes for the prenatal appointments as well. That's not to say that your employer can't always be more generous, which employers certainly can be. Now, to be eligible for the FMLA, you need to have worked 1,250 hours in the year prior to needing the leave. You need to have worked at your employer for at least a year, and you need to have worked for an employer with 50 or more employees within a 75-mile radius. Now we want to move on to a slightly different scenario, where it may not be as clear that the pregnant worker's request for leave falls neatly into one of the buckets of the Families First law or other laws, though it's one that we've seen come up very frequently. And that scenario is, I'm pregnant and work at a childcare facility that is still open during COVID-19. My healthcare provider and I think I should take leave to avoid risk of exposure. What are my rights to leave in this circumstance? In this scenario, because our worker doesn't have COVID-19 symptoms or because she hasn't been told she needs to self-quarantine due to COVID-related reasons, the Families First law unfortunately may not be helpful to her here. The first route she can take is seeking leave as an accommodation under one of the laws my colleagues discussed previously when we spoke about workplace accommodations. As a reminder, if you have a pregnancy-related disability, you may be able to seek leave as an accommodation under the Americans with Disabilities Act. And as we said before, even if you aren't sure whether you have a qualifying disability, you may still be able to ask for leave as an accommodation under the federal law, the Pregnancy Discrimination Act, if they are granting other workers accommodations. And of course, if you live in a state with a pregnant workers' fairness law, then you can request leave as an accommodation regardless of whether you have a qualifying disability and whether or not your employer is accommodating others. While this leave does not necessarily have to be paid unless they're paying others, it does mean that they have to keep your job protected and continue your benefits. Also in this scenario, if your state or locality has a short-term disability law or paid medical leave law, depending on your state's law, if you have been advised to reduce exposure to COVID-19, you may be eligible for disability benefits, but it may vary by state. In New York, for example, you would likely be eligible for disability benefits to reduce risks of exposure. Finally, on the paid time off bucket, we want to cover a scenario where you may need to take other types of leave, and you want to take leave after you've given birth, but you've already used some of that time under another law, like the Families First Coronavirus Response Act. So in this scenario, I'm worried that if I take leave under the Families First law, I won't have time to take leave once I give birth. And what are my rights in this situation? The answer here is really that it may depend. Under the Family and Medical Leave Act, as we discussed, a federal law we discussed before, you're eligible and you may be able to take up to 12 weeks of unpaid job protected time off, including to bond with a new child. However, if you have used up some or all of your FMLA time for another qualifying reason, including if you used paid family leave under the Family's First Law to care for your children due to a school closure, you may have less time or no time left after you give birth. However, we do want to note if you only took emergency sick leave under the Family First Law, which is that bucket of 80 hours of sick leave, and you're also FMLA eligible, you can still take the full 12 weeks of FMLA to bond with your new child. And if you're eligible for paid leave, paid family leave under a state law, you may still also be able to use that time as well to bond with your new baby. If you live in a state with a paid family medical leave law that is already in effect and are eligible to receive benefits, you may still have time available to take maternity leave to bond with your new child under the state law, even if you took FMLA leave to care for yourself, a loved one, or for school closure related reasons. And now I'm going to turn it back to my colleague Elizabeth Gedmark to discuss lactation accommodations.
Thanks so much, Sarah. So, we also wanted to be sure to touch on rights of workers who need to pump during this crisis. Of course, this is always a big issue for women, even in normal times, so it can be particularly difficult right now. So, in this scenario, I work at a fulfillment center and just gave birth. I'm breastfeeding and want to keep pumping, but my employer is giving me a hard time about my taking break time to pump because we are so overwhelmed with orders. What are my rights? There is a federal law called the Break Time for Nursing Mothers Law, which is part of the Affordable Care Act and requires that employers of all sizes provide reasonable break time for an employee to express breast milk for her nursing child for 1 year after the child's birth each time such an employee has need to express the milk. The law applies to employers and employees covered under the Fair Labor Standards Act, or FLISA, and the worker in our scenario is likely covered, but note that unfortunately, FLISA exempt employees, such as some administrative or professional workers, are not actually covered by this federal law. In addition to providing the unpaid break time, an employer must also provide a clean, private space that is not a bathroom where workers can pump their milk without interruption. The law applies regardless of employer size, but if there are less than 50 employees, then an undue hardship exemption may apply. If you are a worker who is not covered under the federal law, many states have their own break time and space laws that may provide additional protections. And additionally, many states with pregnant worker fairness laws that I spoke about before also specify that employers must provide reasonable accommodations for lactation related needs. So, we're not going to cover unemployment assistance at great length in this webinar, but we do want to touch on changes to unemployment insurance very briefly, as we know that more and more workers are facing unemployment, including pregnant workers. So, in this scenario, I'm pregnant and was let go from my job along with my coworkers. What rights do I have to unemployment insurance? Depending on the circumstances, you may be entitled to regular unemployment compensation with some boosts based on a new federal law or pandemic unemployment assistance. Collecting unemployment insurance is an important safety net protection, but do note that you may actually lose your health insurance. The CARES Act, a new federal law which passed last month, created 3 new temporary programs to supplement current unemployment compensation laws by providing additional time and funding for beneficiaries of regular UI and creating a pandemic unemployment assistance program for workers not eligible for regular UI. If you want to know more about unemployment during these trying times, then please visit A Better Balance's COVID-19 resource page, which you can see here on the slides. So now I will turn it back over to Dina.
Great. So, hi everyone. We know we discussed many different types of laws today, and there are several different laws that apply to you in any given circumstances. So this, again, this PowerPoint and our online resources are available to you after this webinar. It's also very clear that more progress needs to be made to secure further, more explicit protections for pregnant workers. For instance, the pregnant worker fairness laws we spoke about are often the clearest and most useful rights workers can invoke in order to get timely workplace accommodations. But only 29 states have those laws, and it really shouldn't be a luck of the draw whether you get those rights or not. That's why we're advocating, along with some wonderful partners, for one federal law, the Pregnant Worker Fairness Act, which should ensure pregnant workers can receive reasonable accommodations quickly and seamlessly, no matter where they live. This law has never been more important, and we implore Congress to act swiftly to pass it, along with other critical measures like permanent paid family and medical leave and sick time laws. And if you're not already involved and you're interested in joining us in this effort, please visit our website or reach out to learn more. Finally, we just want to make it clear we are here to help. These laws are confusing. We have our research page. We've also have created FAQs specifically for pregnant workers with questions about their workplace rights during COVID-19. And within these FAQs, we provide a host of resources for pregnant workers broken down by state. And that is really, really important to understand that state sometimes, not always, but often offer greater protections, and you should always look at your state laws. And we also will walk you through how to talk with your boss about your pregnancy or your need to pump. And if you have questions about your particular situation, please feel free to call our legal helpline at 1-833-NEED-ABB or fill out our online intake form, and one of our helpline lawyers will contact you to discuss what you're going through and provide legal information. So finally, we wanted to thank our wonderful partners who helped share this webinar with their communities and members, including Moms Rising, March of Dimes, National Brotherhood of Teamsters, United for Respect, the Time's Up Foundation, and the United States Breastfeeding Committee. Thank you so much. Now we're going to take a few questions with the remaining time that we have. So the first one we have is, I'll ask Elizabeth, do these protections apply to immigrant workers? Elizabeth, do you want to take that one?
Yeah, absolutely. Thanks, Dina, and thank you for your question. So, for the anti-discrimination protections, which includes the workplace accommodation protections that we discussed, as well as the federal Families First Coronavirus Response Act law, those all apply regardless of immigration status. For unemployment insurance, I would actually refer folks to a wonderful resource from a great partner of ours at the National Employment Law Project. They have an updated fact sheet on immigrant workers' eligibility for unemployment insurance. And I would say to take a look there because that is going to have a lot more detail and nuance, and you can take a look at it.
Thank you, Elizabeth. So I want to know, if I took unpaid medical leave, would I still be eligible for paid family leave um, once I'm ready to go out on maternity leave? Sarah, do you want to take that one?
Sure. I think the answer is it may depend on your circumstance. So, for instance, if you take unpaid medical leave under the Family and Medical Leave Act to care for someone or a loved one or for school closure, and you are eligible for a state paid family leave law, um, or you take it to care for yourself, um, you may have used up that time already, and so you might not be eligible. That said, if it's for different purposes and the state law doesn't necessarily cover um, what you've used leave for in a prior circumstance, you may still be able to take paid family leave. So really the answer is it will depend on your specific situation, which laws apply to you and may overlap. And I would certainly direct someone with a specific question about their own circumstance and whether they've taken unpaid leave to contact our helpline at 1-833-NEED-ABB.
Great. So what do I do if I think I've been discriminated against? And maybe you can just take two at the same time. We got a question about how to access state-specific resources that may apply to you. So do you want to try? Elizabeth, do you want to take both of those?
Yeah, absolutely. So if you think that you have been discriminated against, or if you, in listening to this webinar, realize that you have an additional question or you're not sure how something that we said applies to you, you can always call us at A Better Balance at 1-833-NEED-ABB, or visit abetterbalance.org/get-help, our get help page. And we'd be happy to talk that through with you, answer your questions. And you can also contact your local EEOC office to ask questions or file a complaint. And note that you may have a state or local enforcing agency that accepts complaints as well, which goes to that other question, the second part of the question around state resources. So A Better Balance has a page, babygate.abetterbalance.org, that does have state by state resources. So if, for example, you're thinking, I work somewhere that has less than 15 people, and I want to know if my particular state applies to smaller employers and has a lower threshold, then you can go to babygate.abetterbalance.org, click on your state, and you will be able to see the employer threshold specific to your state on that page.
Yeah, thank you, Elizabeth. I did want to flag in New York, for example, just to underscore that while the federal standard in these discrimination laws are 15, in states like New York, it's one or more now, and it includes contractors. So it's also important to note that some states offer additional protections for independent contractors as well. And I will ask Sarah. This one's a little bit different. It goes to maternity leave and the bias against new mothers. I just finished maternity leave and I'm now teleworking, but my boss is not putting me on certain projects because he said he knows that I'll need to take time to care kids during the day. The three other colleagues on my team are also parents, but are all men, yet my boss hasn't made similar contacts to them or taken them off projects. What are my rights?
So, under federal anti discrimination law, which is the same law that outlaws pregnancy discrimination, your employer also cannot discriminate based on sex, and pregnancy discrimination being a form of sex discrimination. This scenario sounds like it could be evidence of sex discrimination since this worker's boss is making assumptions about her capabilities based on primarily on the fact that she is a woman and a mother. And in addition, we should point out that some states and cities also specifically outlaw discrimination based on your status as a caregiver or based on your familial status. So, again, consulting our state specific resources to see if those laws may apply in your city or state, as well as the federal anti discrimination law.
Okay, great. We got another question. What about an upper level manager with a circumstance of pregnancy provided a doctor's note of restriction to work from home? Employee requested a reasonable accommodation under ADA and Pregnancy Discrimination Act due to telework during COVID-19. Employee reclassified employee as non-essential and advised to take PTO. Employer did not reach the accommodation question. What are the employee's rights? Elizabeth, you want to offer some top line thoughts?
Yeah, absolutely. And as with all of these scenarios, we would always want to talk to the specific individual, and know, more answers in terms of what exactly they said, if they, have any sort of underlying condition that may trigger something like Americans with Disabilities Act protection, gestational diabetes or something like that. But in general, it does sound very problematic that the employer here doesn't seem to be engaging in the interactive process as required, which is required under the ADA. As we discussed under the ADA, if an employee has triggered the interactive process by saying, I have something like a pregnancy related disability and a need for accommodation, then the employer is obligated to engage with them and try and find a workable accommodation um, and not just push somebody out, even if there is paid time, like paid time off. That often is not a good solution for folks because they might be saving that PTO for something like a maternity leave. So yeah, I would definitely be concerned about that.
Okay, thank you. I think we'll take a few more. So how broadly can we interpret the FFCRA in light of the US DOL's regulations? Sort of a policy question. Sarah, you want to take that?
Sure. So I think the DOL put out some regulations that um, we are not thrilled with, like the expansive definition of healthcare provider and emergency responder. And in other ways, there are important pieces to those regulations, like clarifying that a shelter in place order, does qualify as under an isolation order under the law. We, A Better Balance, along with many of our partner organizations, have been trying to push the Department of Labor to come out with regulations that support the most expansive reading for workers and especially the most vulnerable workers. We will continue in the effort to do that. That said, we are also continuing to push for broader coverage, right? We pointed out at the top of the webinar that there are still tens of millions of workers that are denied coverage and exempt under this law, and we still need gaps to fill that law. And I should highlight that A Better Balance on our COVID-19 resource page has model legislation if folks are interested in pushing to fill the gaps in their states or cities that would help fill those gaps in the Families First law specifically. So I would encourage folks that are interested in that to check out our COVID-19 page for that model legislation.
Great. So we got several questions about furloughs, layoffs, and maternity leaves, just combining them all together. Elizabeth, do you want to take those?
Yeah, definitely. So it looks like that's a very hot topic. Question for you all, in terms of what's the deal if I am furloughed or laid off, either with a maternity leave coming up or in the middle of a maternity leave, or upon return of one. So just wanted to talk through a few different things, although again, so much of this depends on a case by case basis. But first of all, the anti discrimination protections that we discussed do still apply, even in terms of furloughs and layoffs. But you would need to have some kind of evidence or reason why you think that you were laid off or furloughed because of pregnancy discrimination. So that may seem like a tall order, but we've seen it before. We've seen where an employer says, "I'm going to lay off, the 5 pregnant employees," and lo and behold, they decide not to lay off many of the other workers, even ones that are not as senior or that are really vital to the workforce. So even in this crisis, if you all are seeing something like that where they really seem to be discriminating against the pregnant workers, please let us know, because there might be something that could be done about that, or there might be some sort of a potential legal violation. Now, if there is just an across the board layoff, the company is really struggling right now. Maybe they just have very little revenue and they've done something like across the board huge layoffs or furloughs, and it doesn't seem to be targeting pregnancy. The fact that you are pregnant or on maternity leave doesn't really add an additional layer of protection in terms of meaning that you can't be laid off when everyone else can. And that's not just happening in the COVID-19 situation. That's always. So under the FMLA, the Family and Medical Leave Act that we discussed before, if there's massive layoffs, then the person on FMLA leave doesn't get, they don't get to be, not laid off, basically. And the one other thing I would flag is that I would urge you to visit our resource page about unemployment insurance, because there could be unemployment insurance available for furloughed or laid off workers.
Thanks, Elizabeth. So we got a question from a healthcare provider, a nurse about what types of. So I'm going to paraphrase to sort of what types of accommodations can healthcare providers ask for. Um, Sarah, in specifically asking their physician for or their healthcare provider.
I think it's a really important question that we've been hearing as well, and a common scenario is, I am a nurse and I'm pregnant and working directly with COVID-19 patients, and I'm nervous about risk. What kind of accommodations can I talk with my physician about? And one, in addition to, personal protective equipment, which is something that hopefully all healthcare providers are getting, but if not, seeking as accommodation. If this worker is interested in something like telework, that is an accommodation that they may be able to ask for. And one common accommodation that we've been seeing and may be helpful to this worker are helplines that are being set up by hospitals where they're providing, telemedicine, or not just telemedicine, but a helpline for internal use, where nurses can be helpful. So that's just another example of how the nurse can keep working, not necessarily be pushed out onto leave, as it sounds like in this scenario, this worker wants to continue to be working, but in a safe environment. And we've been finding that these sort of nurse helplines are one kind of accommodation to ask for.
Yeah, I just want to underscore that point. These are not mandates. This is all rooted in an interactive process between workers and their employers. And in places like New York City, it's called a cooperative dialogue, which basically means rather than shutting down an employee's request, it's engaging and evaluating in light of the circumstances whether an accommodation based on that individual's individual needs and circumstances is available absent undue hardship to the employer. That is the standard. That's the ADA standard. That's a similar standard in all of these state PWFA laws. And that's how workers and employers should be thinking about it. And healthcare providers and physicians should know about these state laws because they do exist and they can, in many circumstances, help pregnant workers in ways that could provide, help keep them healthy um, and earning a paycheck during their pregnancy. Okay, I know this has been going on for a long time. We will end it with two more. This is pretty straightforward. Maybe I'll just answer this one. I think my boss is discriminated against me because of my pregnancy, but I'm scared of filing a complaint. I think I'll be fired. Is there anything to protect me? Well, this is, anti-discrimination civil rights law, protects you from retaliation. Your employer can target or discourage you from filing a complaint. But if you're still scared, you can discuss the laws with your boss, your HR before filing a complaint. And I will say that, to underscore what we do in a better balance is oftentimes our hope is to resolve situations informally by arming individuals information about their rights. So first trying an informal conversation, pointing to resources, engaging in a good faith conversation, and hopefully, that will take you a long ways towards getting what you need. And obviously, if not, then you need to think about additional steps. So I think there's one last one, and then I promise I'll wrap up. This is about the FMLA and the 75-mile radius. Do one of you guys want to take that one? Just the limitations, I guess, unfortunately, the FMLA around that. I think it's a very fact-specific question. Maybe we can also just ask the caller to follow up directly with us.
Yeah, absolutely. But the FMLA does have some requirements in terms of, so Sarah had covered before the eligibility that it has to be 50 or more employees. And that is really the way that they define and look at how many employees there are, is looking at a 75-mile radius of the employee's worksite. And then there's very specific regulations about how they even measure those miles and how they look at the worksite. And count folks on payroll. So yes, I would encourage the I was going to say caller, but the participant to reach out to us if there's additional questions.
All right. Well, with that, we will end this webinar and thank you all for making time to join us and learn about this complicated but important issue. And hopefully, we'll be able to use these resources to work with your communities, with your patients, with your members, and we can all be working to ensure pregnant workers, know their rights and and maintain as healthy a pregnancy as possible. We'll be following up again with a recording. And thank you so much again. Have a good afternoon. Bye.